don't think we need to get into on this. Someone wants to say something?
Yeah, I do.
You want to interrupt me? Go ahead. Go ahead.
Please.
I will respond to you.
Please.
No, go ahead. I invite it.
All right. Department 16 is now in session. I'll turn you to presiding. Please be seated.
Go ahead and say whatever you
Good afternoon, Teddy Parker, Eric Pepperman, and Will Kemp, on behalf of Plaintiffs.
Your Honor, Jim Neale, Nick Hoffman, David Spurlock on behalf of UNFI.
Good afternoon, Your Honor. Joel Levy on behalf of Real Water Inc. and the Trinity Lifestyle.com.
Good afternoon, Your Honor. Scott Rasmussen and Ryan Flanagan on behalf of Hanna Instruments Inc. I'm not sure where Rob Robbins is this morning, but I think I can take care of some of those things that may pop up for him today.
I understand.
Afternoon, Your Honor. Jim Kavanaugh for Real Water Tennessee LLC.
And good afternoon, Your Honor. This is Rob Robbins. I'm under the weather today, so I sent Scott a message, but I don't think he's seen it yet. But it was for Milwaukee Instruments appearing by Blue Jeans.
Okay, sir. I hope you're doing better.
Thank you.
Okay, so.
Just one very minor housekeeping item. I have provided the court and set them in front of Ms. Victoria a couple of binders of 2 deposition transcripts. They're of Mr. Carl Sauvage and Mr. Tim Shannon, both employed by Hanna Instruments Inc. Again, I said that I provided them to Eric Pepperman. He has reviewed those. They will not come into play today at all, but in just knowing what we are going to be dealing with down the road, I thought I'd get ahead of the game and make sure that they were available for the court. That's all.
And thank you, sir.
And Your Honor, I would just add that one of the plaintiffs, Patricia Sutherland, is present in court this afternoon. She is one of the heirs and the sister of Kathy Ryerson, who's the decedent.
I understand, sir. Okay. So where do we go from here?
Your Honor, I believe we're on UNFW's motion to eliminate number 7, which deals with unrelated recalls.
All right.
Thank you, Your Honor. And Jim Neale for UNFW. I'm going to start with a bit of an apology. Our motion to eliminate number 8 also deals with a recall. And for the life of me, I don't understand now why there are 2 separate motions. With the court's permission, I'll take them both up here. I think the ruling on one will govern the ruling on the other. The plaintiffs filed a joint opposition, and I wish I had come to that realization sooner.
All right. Any problem with that?
No, Your Honor, like Mr. Neal said, we did file a joint opposition because we thought they were substantially similar as well.
This is where I joke about Mr. Kemp thinking that everything's substantially similar and providing a basis for the other similar incidents, but I appreciate counsel's cooperation there. Judge, this motion to eliminate concerns 5 news articles. John, if you could pull up Exhibit A, please, page 25. The 5 documents are all hearsay documents. This is the first of them, Your Honor. It is a news article from the National Association of Convenience Stores newsletter talking about a bottled water recall in 2015 involving concerns for E. coli and a number of different brands. The second one, John, Exhibit A, page 27, please, is an article in the Guardian newspaper, a UK publication, about a Consumer Reports article about an arsenic investigation. And it concerns arsenic levels in bottled water that are generally below the 10 parts per billion that the FDA allows. But Consumer Reports and the Guardian expressed some concern about that. There is some reference in this article to a prior Whole Foods recall of Starkey spring water for a arsenic test that was above 10 parts per billion. The third document, Your Honor, is I think related to the second. If you could go to page 36, please, John. This is an article from Ethics, Law, and Procurement, publication I've never heard of before, but it also concerns a recall over arsenic levels in water manufactured by Keurig Dr. Pepper and branded as Penefiel water. The next one, Your Honor, is Exhibit A, please, John, page 38. A list of 32 separate products from the Whole Foods website. They maintain this website, Your Honor, as a customer service so that if you're a shopper at Whole Foods, you can see if any of your products have been recalled. Mr. Kemp has apparently put in some date ranges, all of which post-date the real water recall, and use this exhibit at depositions. None of these involve water at all, and none of them involve real water. And then finally, Your Honor, the fifth document is an FDA letter to Whole Foods dated 12/16/20. That's page 42, John. This concerns, if you could scroll to page 2, please. This concerns in-store products, salad bar, hot dinner bar, those kinds of things that are prepared at the store, but were generally speaking mislabeled. They were labeled in a manner that omitted an allergen. I think there are 8 or maybe 9 now: sesame, milk, eggs, shellfish, tree nuts, peanuts, etc. And it's not at all uncommon for misbranded items to be recalled because the ingredient list doesn't contain that allergen. Thank you, John. At each of the depositions taken of any Whole Foods employee or UNFW employee, these documents were put in front of the witness. The witness was asked about them. Mr. Kemp read from them. The witness confirmed that Mr. Kemp's reading was accurate, and in no case, Your Honor, did a single witness know anything about the underlying recalls. They're just pulled off the internet. None of them concern hydrazine. None of them concern, 2 of them don't concern bottled water at all, the 2 Whole Foods documents. None of them concern alkaline water. Certainly none of them concern real water. There's not even any evidence, Your Honor, that UNFI distributed any of these products that were recalled. The 5 documents are all hearsay and should be excluded under 51.065. And Your Honor, they're all subsequent remedial measures. A recall is an important public health tool that manufacturers and distributors and retailers use to keep people from suffering harm from an adulterated or potentially misbranded product. And that's exactly what happened here. There is none of these recalls resulted in any hepatitis. None of them resulted in any liver injury. None of them resulted in any injury at all, as best we can tell. There's no report in there of a single consumer being ill or suffering a problem, never mind a problem like the ones alleged by Ms. Ryerson and the other plaintiffs in this matter. So they're dissimilar in terms of product, they're dissimilar in terms of injury, and they can't be used for notice, Your Honor, because there's also no evidence that UNFI was ever aware of any of these until Mr. Kemp printed these off the internet years after the fact and showed them to deponents during the depositions. So for all of those reasons, the recalls themselves in these 5 documents are inadmissible hearsay that should be excluded. But there's a more fundamental issue, and I'm sure the court's read the papers and is aware of the plaintiff's opposition. And as I understand it, Your Honor, that opposition is fundamentally premised on the fact that these are prior incidents that are admissible under Nevada's liberal similar incidents law, and that they provide notice. They certainly can't prove causation or defect because they're different products with different problems that didn't cause injury. So the only potential issue would be a notice issue. But again, unless they were provided to Whole Foods, there can't possibly be any notice. Even more fundamentally is this point, Your Honor. A recall is not a prior incident. A prior incident under Guinness or Harley-Davidson or Benedy, the Fourth Circuit case that plaintiffs repeatedly cite in support of their efforts to admit other illnesses or injuries. A prior incident is the injury or the illness. It's a consumer suffering the harm that the plaintiffs here allegedly suffered. It's not a measure taken to protect the public health and prevent that injury, in these cases successfully, from ever happening. And so there's no case at all for a recall to be mischaracterized as a prior incident. None of the cases, and I want to say this twice, none of the cases that plaintiffs cite involve the admission of a recall to prove prior notice. There are several reasons for that. One is because it can't possibly be a prior incident. Number two is that it's a subsequent remedial measure that we don't want to punish retailers, distributors, and manufacturers for taking. If anything, we want to incentivize that behavior so that potentially harmful products are removed from shelves quickly without deliberation to prevent any harm. The more potential there is that a recall is later used against a retailer or a distributor or a manufacturer, the slower that entity will be to issue a recall. And so for that reason, I urge the court to pay careful attention to the subsequent remedial measure aspect of the argument. But this is the fundamental issue, Your Honor. A recall does not prove that a product is unsafe. A recall is a means to ensure that an unsafe product does no harm. Two completely different purposes. And very, very important that the court keep that distinction in mind. I'll again say this, there are, in the 5 documents that Mr. Kemp seeks to introduce into evidence or used in discovery, there are exactly 0 injuries. And there are 50+ recalls referenced. The recalls did exactly what they were intended to do. They kept people safe. That's what we ought to be encouraging. The last thing in the world we want to do is let a personal injury plaintiff use that as a sword. Now, Mr. Kemp is free, of course, to cross-examine witnesses and say, bottled water can have E. coli in it. Bottled water can have harmful metals in it. Bottled water can have any number of different potential problems. But to use these successful prior or subsequent remedial measures as a specific sword, particularly when they're hearsay, would be wrong. And I want to briefly just go through them and illustrate some of the manners in which there's a mismatch between what Mr. Kemp says these are being used for and what we can reasonably infer from them. John, can you go to Exhibit A, page 25, please? The first one is this Niagara recall, Your Honor. And John, can you split that so that we see page, let's start with that. And highlight the bottom if you would, please. So Niagara bottled water, Your Honor, has another source. This source was, Niagara's in Ontario, but I think the source was in Pennsylvania, if I recall correctly. And the source called up Niagara and said, hey, we found E. coli, not in our water, not in the water we get, but around our facility. And we want you to know that. So then Niagara in Pennsylvania looked for E. coli, and it didn't find any. Didn't find any in its facility, it didn't find any in its water. But it nonetheless issued a recall for all the water it ever got from Ontario, from Niagara. It did exactly what we hoped it would do, even in the absence of a demonstrated problem. it took that in an abundance of caution measure to prevent any possibility of E. coli from reaching grocery store shelves. And it was apparently very successful because they say that even the samples they got back from consumers are negative for E. coli. No injuries at all reported. Again, no evidence that Whole Foods ever sold this brand. No evidence that I'm aware of that this brand was ever even sold at Whole Foods. I think it may have been sold at Shaw's, a former employee of one of the Whole Foods employees who was deposed here. So, was this a success story? Absolutely. And does this prove that bottled water is dangerous? Absolutely not. It proves that companies try to do the right thing with recalls. Letting a problem reach the market is never a good business model. And to their credit, these companies did exactly what we would hope they would do as consumers, and they pulled the product from the shelf. Mr. Kemp wants to use this to say, bottled water is inherently dangerous. We shouldn't treat it as a low-risk product. We should do audits of every single supplier we have. Now, first of all, Your Honor, no distributor, and I'd ask the court to keep in mind, we, UNFI, is a distributor. We drive trucks. We move boxes from one place to the other. We don't sell product to consumers. We don't select which product goes on grocery store shelves. Our customers do that, the retailers. There is no evidence in this case that any retailer audits all of its suppliers, none. And yet that is the burden that Mr. Kemp would foist upon UNFW. Even if we had that burden here, though, I want to explain why it wouldn't make any difference at all. Even if we had notice of this recall, and even if we had decided that this is going to prompt us to go audit Niagara in Pennsylvania, there never was E. coli at Niagara. Not in its product, not in its facility, not anywhere. We could have set up camp there 365 days a year, tested every bottle that came out of the facility, and never ever found the problem that prompted this recall, or the potential problem, I should say. So no injury, no illness, no similarity, not the same product, no notice. There's not a single criteria of this recall that makes it relevant, certainly not for defect, nor for notice. The second one, John, if you could go to page 27, please. This is the arsenic article, Your Honor. And again, this is about, it's hard to keep track. To reiterate, this is a Guardian article about a consumer report investigation that contains quotes from environmental advocates and plaintiffs' lawsuits. So it's at least 3 layers of hearsay. Most of the article is essentially a critique of the regulatory regime, saying that the current guidelines of 10 parts per billion for arsenic are inadequate, and that some potential for adverse human health effects exist below that. John, can you go to the bottom of 27 and the top of 28, please? So this lays out the issue. These are investigative journalists who are taking the FDA to task and who acknowledge that most of the water on the market tests well below the applicable regulatory limits, but that we think the regulatory limits should be lower. And there is, I think, a line in the article that acknowledges that at one point some testing indicated that some Starkey's water was at 12 parts per billion. Instead of 10, and the 2,000 cases of water were recalled by Whole Foods. Again, that's not water that UNFI distributed. It's not a recall that UNFW had notice of. That's not a recall that caused a single injury. It was a preventive, abundance of caution, voluntary recall that we want to encourage, and certainly not sanction or punish a company for. Just to illustrate some of the problems with this article, could you go to, just pull up page 28 there, John, if you could, and right below, the paragraph below, America's water crisis. Excuse me, America's water crisis. This is the third level of hearsay. So we're now past the consumer report investigation, and we're interviewing the National Resource Defense Council, Senior Strategic Director of Health and Food. Page 33, please, John. There are other quotes. It quotes consumer lawsuits about arsenic in water. Again, none of them target Whole Foods. None of them target UNFI. None of them allege an injury. But all these quotes are here on the third level of hearsay. So again, Your Honor, that is not a prior incident. It's not the same product. It's not the same injury. There's no notice to Whole Foods, and it shouldn't come in. Page 36, please, John. This is the third article from the Ethics, Law, and Procurement magazine, not one that I subscribe to, but perhaps the court is familiar with it. Again, this details the same. Another manufacturer recalling for arsenic. Next page, please, John. This one contains, and then it shifts. Meanwhile, the Missouri Court of Appeals, can you get that part from there down, John? Then the second half of the article is devoted to Johnson & Johnson's tort verdicts with billions of dollars in punitive damages. Obviously different product, different manufacturer, completely unrelated to the issues at hand. Exhibit A, page 38, John, the Whole Foods list of recalls. Can you just pull up some of those, John, so that they're a bit more legible? Thank you. These are all manufacturer-initiated recalls, Your Honor, that Whole Foods is just simply relaying to its customers so that they're aware of it. You can look at this list and scour it. There's no bottled water on here. There's certainly no real water on here. And I don't think that there's any hydrazine toxicity on here. We want companies to broadcast recalls. We want companies to execute recalls. And we want companies to implement recalls quickly and decisively. And the sort of motions that's before the court thwarts all of those objectives. Last one, please, John. Exhibit A, page 42. This is the FDA letter to Whole Foods Market. And I agree with the FDA. If Whole Foods employees in a store are not properly labeling the sesame crusted salmon that they put out, or the peanut containing salad that they put out, they need to be. But that's what this, page 2, please, John. These are all in-store manufacturers. This has nothing to do with a supplier or an auditor, and nothing to do with a distributor like UNFI. So, again, Your Honor, I'll wrap up and reiterate. There can't possibly be causation or defect because there's no injury on any of these. It can't possibly be causation or defect because it's not the same product. And certainly not the same injury. There's no hepatitis. In terms of notice, none of these involve UNFW products. None of these are recalls that UNFW was aware of before Mr. Kemp brought these articles to their attention at depositions. And all of these recalls stand in stark contrast to the cases that Plaintiffs cites. The Ginnis case, of course, with the malfunctioning door, same door that injured people dozens of times, and that the defendant had actual notice of and many repair orders concerning. It's not like Benetti, which was one product, Tylenol, that resulted in acetaminophen toxicity. Same injury, liver injuries in that case. Here, there's just none of those things at all. It's the opposite of those cases. Therefore, it's not a prior incident, and it's not admissible for notice. Again, Your Honor, last point, a recall is not an indication of an injurious risk A recall is a means to prevent that potential risk from manifesting itself in a consumer. And the last thing in the world the court ought to be doing is allowing somebody to use a recall against a distributor or retailer, particularly when it's not theirs and it's not the same product. Unless the court has questions, I'll surrender the floor.
Not at this time, sir. We have some
Your
joint.
Honor, Real Water had joined this motion, it doesn't appear on the docket, so this will be one of those that we need to correct with the clerk.
Mr. Kemp.
Good afternoon, Your Honor. Your Honor, basically what is sought to be admitted here is evidence of 3 prior bottled water recalls in the FDA lab. There's a number of ways we can admit it. We can have our expert discuss it. We can play the deposition testimony. As counsel indicated, one of the Whole Foods employees worked at Shaw at the time of the Shaw bottled water recall. The other recall was a Whole Foods recall, and they had knowledge of the other recall. So we don't need the news articles, and really I hadn't intended to offer them. I hadn't really thought about it until counsel brought up that possibility. But in any event, the object, the evidence that we're going to introduce are the 3 prior bottled water recalls and the FDA letter, which he didn't read the critical part of. But in any event, these 3 prior incidents all involved bottled water, and they had toxins in them. True, they weren't hydrazine, but they were toxins such as arsenic in I think 2 of the cases, and E. coli in the other case. One, as I've already mentioned, was at Whole Foods itself. Several years ago, I think it was in 2016, it was their plant in Arkansas. To suggest that they don't have knowledge of this, when it's their own branded labeled product, I think is not appropriate. But our point is that these 3 prior instances are notice of the potential danger of bottled water. There's notice of the potential danger of bottled water. And why is that an issue in this case? That is an issue because UNFI, multiple witnesses, and I'll show you their testimony in a second, multiple witnesses have said, oh, well, we didn't know that there was a potential risk of bottled water, so that's one of the reasons we weren't auditing, having third-party audits. Well, first of all, that's not true, because they just didn't do third-party audits of 6,000 of their products, whether they were bottled water or not, okay? That's really not why they didn't do the audits. But now, and I will show you Mrs. Capadia's testimony in a minute, she says, oh, now that I know about the real water outbreak, our risk assessment has changed. No longer do we think it's an ambient, that's the term you'll see used in these deposition clips. Ambient, which means innocuous, can't cause harm. No longer do we think it's an ambient product. We now understand that there's a potential danger, and that's this is her testimony. That's caused us to change our risk assessment, okay? So their position is, first of all, that there was, in their view, no danger, and that's why they didn't do the audit. And now they've said they've changed their risk assessment because they know about this recall. That, I think, is the best possible proof as to why the prior recalls are relevant. Because this proves that they should have done what everyone else in the industry was doing. They should have had third-party auditors go in there and take a look at these places. So the evidence is admissible for 2 basic reasons. First of all, as I've said before, it's notice of a potential danger of bottled water. Now, talking briefly about the Nevada law, counsel just said that Guinness versus Mapes requires that it be the same door. That is totally wrong, Your Honor. If you take a look at Guinness versus Mapes, that's the case that says same or analogous, okay? That's the test in Nevada. Same or a similar type of door. Same or similar type of crushing machine is what we had in Robinson. Same or similar type of motorcycle is what we had in the Harley-Davidson case. It doesn't have to be the exact same product. to give notice of potential danger. And it doesn't have to be the exact same toxin in a bottled water recall to give a distributor notice that there is the potential for a problem with bottled water. Okay, why don't we have the first clip? This is, I believe, Mr. White. Mr. White is, and where I'm gonna go with this, Your Honor, is the evidence. If you saw in the motion, we incorporated in section 1, part of the opposition to their motion to dismiss the punitive damages claim, the motion for summary judgment, I should say, on the punitive damages claim. And as bullet point 2, we incorporated another part of it. So a lot of this stuff is coming from the punitive damages briefings. And the punitive damage argument is pretty simple. There was an industry standard that requires a distributor to go out and do third-party audits on all of its supplier. Mr. Neale said no one in the world does that. I think he misspoke because he knows that Costco does it. They go out and do third-party audits on all of their suppliers. That's the industry standard. That's not what was done in this case. What was done in this case is they did 6,000 of their 12,000 suppliers. They didn't do the other 6,000. And the reason, the excuse they give for not following the industry standard is that this is so supposedly an ambient, a safe product. It's just water. And that's why these 3 prior incidents in the FDA letter are so important, because they prove without doubt that this entity should have known that they were taking a big chance with people's health, some cases their lives, by not inspecting these facilities. So the first clip is Mr. White, and again, he's one of their employees, and he's explaining the reason why you do third-party audits. I think it's pretty obvious, but at least they do know the reason.
Did UNFI ask Real Water for the results of any sanitation or food safety audits?
Let's stop right there, Chris.
No, we did not.
Your Honor, they had a couple options here. One, they could have required them to do third-party safety audits. 2, under the contract, they had the right to request anyone that anyone else did. They didn't even ask for anyone else's food safety audit. Go ahead, Chris.
And that would be true from the entire time period 2012 to the present. You didn't ask for any audits, correct?
Correct, because they're an ambient, low-risk product.
Stop right there. There's their excuse, Your Honor. They were bottled water is an ambient, low-risk product. That's why these 3 prior recalls of bottled water facilities, 2 for arsenic and 1 for E. coli, are significant. It is notice of a potential hazard of bottled water. And again, this is his excuse for not doing what the rest of the industry was doing. Now, with regards to whether this is an industry standard, because at one point, Mr. Neale said that UNFI is a trucking company. I guess later on, at the very end, he admitted they were a distributor, but he said, Judge, we're just a trucking company. We move it from one place to another. That's not what they do, Your Honor. They buy the product from Real Water. They enter into contracts with the food suppliers. They move the product they buy into their warehouse, and then they distribute it. Primarily to Whole Foods, that's their big customer, but they do have other customers. To suggest that they're just a trucking company, I don't know of any trucking company that actually enters into contracts with suppliers. In any event, on the industry standard point, this first of all is Dr. Hutt. Chris, Dr. Hutt's our quality assurance expert. This is from her deposition, Your Honor. She says, as I said, it's standard within the retail food industry of auditing one step up and one step back, or one step forward, I should say in this case. But that would be the expectation, and again, that is the standard, the gold standard within the retail food industry to have a SQF audit. Okay, by one step up, one step back, the party who you're buying the product from, that's the party you should audit. If if Real Water had been purchasing some product for their product and mixing it, they would have the obligation to go do the one step back audit. But in this case, UNFI was the direct purchaser for Real Water. It wasn't Whole Foods. It was UNFI. And so what Dr. Hutt is saying here is that it's the standard of the industry that they should have required a third-party audit. Next one, please. This is Debbie Castillo. She's the buyer for Costco. She's going to testify, or she has testified, and this is the pertinent portion of the clip.
In other words, Costco sends an independent third party to the actual location of the vendor, and that third party does some sort of audit. Is that correct?
Sounds right.
So what happens is every single item that is sold in Costco, food item, gets a third-party audit. And the company they use is called NSF. We're going to see the NSF report in a minute. So Costco, and as I said a couple days ago, most of the other big retailers, Kroger's, Albertsons, Walmart, Sam's Club, they also require third-party audits of all of their products. But UNFI just does half of them. All right, and the next one here is Mr. Brown. Can we have that?
I mean, how did they decide what's ambient if it's gonna be consumed by humans, by people?
All of them were consumed by people. All of the 12,000.
But my point is, whether it's pasta or tomato sauce, or Coca-Cola, or anything that's being consumed, you have a possibility of potentially tainted product causing harm.
Well, that's the way most of the industry looks at it. That's the way I look at it. But that's not the way they look at it. They look at it that we can do our own little internal risk assessment on each one of these products and decide which ones are ambient or low risk, and we're not going to audit those. That's what they did, Your Honor, and that's why it's so important to have the 3 prior bottled water recalls evidence, because that totally, one of their own, one of them was a Whole Foods product, that totally shatters this claim that, it's just water? Why would we send someone to audit a water? Next one, please, Shane. Sorry, Chris. I'm used to Shane. Need a minute, Chris?
Yeah, it's, I apologize.
take a break?
Please.
Judge, will you have 5 minutes, please?
Yeah, we can.
Mark? Mark, please.
All right. Department 16, now come back to order. Please be seated.
Yeah, 1 minute, please. Okay, Mr. Kemp, you're ready to continue, sir. Okay. Okay, we'll have Mr. Brown's testimony.
Having third party, in your official capacity as employee of Whole Foods, do you think some consideration should be given to having third party audits of all suppliers as opposed to just half the suppliers like you're doing now?
Ideally, every supplier should be audited.
Okay. So why doesn't Whole Foods do that?
I don't know.
The reason that they don't do it is explained by the 2 other witnesses, that they consider it an ambient odorless product, Your Honor. But this guy is the head of recalls for Whole Foods, and he admits that they should be, ideally, they should be auditing everybody. And he doesn't know why they don't do it. Next one, please, Mr. White.
Would I be correct that some people did require, say in 2018, they did require suppliers to do annual audits and provide them to them?
It would be possible that others did, yes.
And more specifically, Costco did that, right?
From what I saw in the binder as of yesterday,
Right?
yes.
So Costco in 2018 was basically doing what UNFI is trying to move to in the future, right?
To a degree, yes.
So what they said at the deposition was, even though their policy was still to only audit half, that they were trying to move and get more and more as years go by. That's what the move to refers to. Next one again.
And was that standard in the industry for a supermarket chain of that size to do annual inspections of its suppliers?
Yes, I believe that was probably standard.
Okay, stop. He's talking about Shaw's.
Other people were doing it.
Yeah, Shaw's Markets, which is a big supermarket chain on the East Coast that he worked for. That's what he's talking about, a supermarket chain of that size. That's not even one of the national chains. That's a little regional chain that's auditing all the suppliers. Go ahead, finish it, please.
People were doing it.
Yes, other retailers were doing it as well.
And do you know what other retailers were doing annual inspections of their suppliers back in, where were we at, 2004?
At that point in time, Albertsons, Stop and Shop, Food Lion.
Anybody else you were familiar with?
Winn-Dixie, Publix, I think most of the major supermarket chains, Kroger's.
And Your Honor, notice that he said in 2004. This has been the industry standard for 20 years to audit all of the suppliers. And yet UNFI only does half. Now my next one, this is Mrs. Capadia, I believe. Mrs. Capadia is the #1 person in food safety at UNFI.
Is it true that UNFI did not request at any time the annual third-party inspections, if any, that Real Water had?
During that time, we did not request any audits.
And this is referring to the time that they were under contract with Real Water, which was 2012 through 2020. Next one, please.
What page is that, Mr. Kemp? Sorry.
I think it's, according to my notes, it's 118, 18 through 23.
So UNFI made a deliberate decision not to have annual third-party audits of bottled water facilities. Is that correct?
UNFI made a conscious decision to focus our resources on high-risk items.
Okay, stop right there, please. So, Your Honor, in the punitive case, I need to prove that there's evidence to suggest that the defendant made a conscious decision not to follow an industry procedure. This guy is just admitting that right here. He is admitting the whole punitive claim. But, back to this motion, you see they are going to focus their resources on high-risk items. So rather than audit all the food and water products, they're just going to do half of them that they decide are high-risk items. Okay, next one, please.
Now, let's assume that you had a bottled water supplier that has no food safety plan, no HACCP training for its employees, a lack of quality assurance or quality control director for an extended period of time. This is flagged on an audit and it's not corrected. Is that something that you would suspend the bottled water supplier for?
If I was made aware of it, yes.
Okay, so this is the UNF guy. He's right under Mrs. Capedia, so he's the number 2 food safety guy. And those points that we just raised, the lack of quality assurance director, blah, 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 we're going to see the NSF audit that Costco did in 2 seconds. All of those came straight from the NSF audit, every one of those points. And so he is saying, and this goes to the causation issue, he is saying that if he knew these things, if he had done an audit, he would have suspended, which is the only logical thing to do. Can we have the 2018 NSF audit, please? Your Honor, NSF is one of these auditing companies. There's probably, there's 3 or 4 dozen of them, but NSF is one of the main ones. Not the main one, maybe, but one of the top 3 for sure. So what Costco does, and what all the other people in the industry have done since 2004, is they require all their suppliers to have an annual inspection by one of these audit companies. This is the Costco audit for Real Water for 2018. Costco was selling Real Water, I think, from about 2015, and then in March 20, I believe they stopped buying it because there were a lot of concerns, which I don't think we need to get into on this. Someone wants to say something?
Yeah, I do.
You want to interrupt me? Go ahead.
I'd
Go
like-
ahead. I will respond to you.
Please.
No, go ahead. I invited.
I think the reason for the Costco discontinuance was very different than what you just represented to the court. We'll go to Ms. Castillo's
If you
definition.
want to see, I'm going to show Mrs. Castillo. If you want to go to the emails from Costco, I'd be more than happy to do so, as opposed to.
We'll get to that later. I want to see this.
Okay.
I want to see this right here.
Again, Your Honor, this is the NSF audit. This is the audit that Costco had an inspector come in. The inspector's name is on there. You see Auditor Leela Said.
And what date is this, Mr. Kemp?
This is December, I think 18th, 2018. It's December of something, December 6th. So they started the audit that morning at 8:55, and they finished the audit at 6:30. So she's there all day. And so these are the things she finds okay, in the red. Let's go to the HACCP portion. HACCP is the critical analysis done not just on food plants, but others. It came out of the NASA program. This is how you basically do a systems check to make sure the system's right. So this is the most important part of the audit, the HACCP portion, section 3. So item number 1, does Real Water have a HACCP team? I go, no, not current. 4 member positions on the HACCP team. 3 of them are handled by the VP of Operations, that's Blaine Jones. Okay, anybody here who's had some HACCP training? No current staff that has completed HACCP training. They had a scope of the plan. 4 is their description for each product, okay? And you're gonna hear testimony that they didn't let anyone into this concentrate room. And the quality assurance director is gonna testify that there was no way she could fulfill her HACCP responsibilities without knowing what the ingredients were for concentrate.
Is this the woman that was the receptionist?
This is Patty Converse testifies to this. Okay. So no here, they failed. So now we've failed 3 out of the 4. 5, there's a flow chart, how you're supposed to manufacture the product. They didn't have that. Okay. 6 is you're supposed to go on site and verify the flow chart. Flunk that. Next one has a hazard analysis of all biological, chemical, radiological. And the current hazard analysis study was observed was not current. Answer is no, so flunk that one. Next one, we got not applicable, 2 not applicables. Next one, 2 more not applicables. Go ahead. Did they verify the plan internally? No, they weren't even looking at their HACCP plan. Last time they looked at it was February, which was 18 months before this audit, so they flunked that. New blow molders referenced. Do they keep good records? No. So basically, when you take the not applicables out, which I think there were 4 of them, there were 10 questions here. 2 of them they passed, 80% they flunked. Look at the score, 6.7%, 10 out of 150 on HACCP, the most critical thing in a food or bottling plant. Okay, so I asked the witnesses, is this a good audit or is this a bad audit? Let's have Mr. Pham's testimony. Mr. Pham was the quality control director for a brief period of time after Mr. Desital, who they didn't bother telling me that he was the quality control director.
So back to this NSF audit that we have is 18. This is pretty poor audit result for a company.
I believe so. I never had this comes in and sells so many demerits.
Okay. Is this one of the worst or the worst you've ever seen?
Yes, I have. That's the worst.
Well, I mean, obviously, this is a terrible audit, Your Honor. And I forgot, can we go back to the NSF audit? I forgot my favorite part. Okay, after the HACCP thing, go on to the finding about the qualifications of the people making the, go down a little bit. Right here, Your Honor. I mean, you can't make this stuff up. Quote, there was no qualified individual to provide a level of competency necessary for production of clean and safe product. The QA director has left the company. And I believe that's a reference to Patty Converse, the receptionist and QA director. But the auditor says, quote, there was no qualified individual to provide a level of competency necessary for production of clean and safe product. I mean, how much worse could it be than that? Okay, we're going to go back to Mr. White, and I think we're going to start seeing what their excuses were for not doing third-party audits.
If I told you that.
Go ahead.
Okay, if I told you that one of your.
There's 5 of these clips in a row, I believe, right?
Do you mind giving me the site so that we can follow along?
I do mind. Go ahead. They're all cited in the punitive damages opposition. Go ahead.
No, that's okay. We have to be fair, Mr. Kemp. I mean, the facts are the facts, though. Right?
Okay, if you take a look at the punitive, do you have the punitive damages opposition? I do. Okay. Chris, is there a way you can read them? Because I didn't write down the numbers on all the white ones.
This is 8713 to 8720.
Thank you.
All right. Is that all 5 of them, or is that the whole thing?
No, there's
Give
they're
them all to
separated.
them so we don't have to stop every time.
Okay. The next one is 98 through 17. So 90, line 8 through 17. 93, 17 through 94, 2. 95, 10 through 15. And we started with the first one, which was 78, 10 through 21.
Thank you, Chris.
Chris, let's do 1, 2, 3, 4, 5.
Okay, but if I told you that one of your bottled water suppliers didn't have anyone that was competent to make clean and safe bottled water, would that raise red flags for you?
There would be a reason to investigate the circumstance.
If they still had no current staff that completed formal HACCP training as of February 13th, after being flagged for it by the auditor on December 8th, would that be a red flag or to UNFI?
If we were made aware that they failed to complete the corrective actions, yes.
With regards to these 3 findings, just in and of themselves, the lack of HACCP training on the employees, the lack of the ingredients list, no quality control director, would that be enough to trigger a suspension by UNFI if you knew about it?
If we were aware, yes. It would be enough to start an investigation of the supplier.
So in a matter of days, UNFI would determine whether or not to suspend them.
Yes,
And if these 3 points weren't corrected, they'd be suspended.
correct.
That's all.
Your Honor, next, I want to go to Mr. Heidel. Mr. Heidel is the bottled water expert that was hired by Milwaukee. And as I said, or Hannah, was it Hannah or Milwaukee? I can't remember.
It's joint,
Joint,
so
okay.
that's fine.
Okay, so, he has some pretty impressive credentials. He started basically every bottled water association that's ever been formed. He's inspected over 1,000 water bottling plants around the world. And so we asked him what he thought about this whole situation. Do we have it?
Have you ever seen anything this bad where they have nine deficiency areas out of 10 HACCP ratings?
Not in recent times.
Bottling water expert, Your Honor, and we already played Mr. Pham. Now, let's move back to the excuse they're using to justify not doing what everyone else in the industry has done for 20 years. This is what Mr. White said in response to my question as well. Why didn't you get a third-party audit of real water?
So is it fair to say that you assumed that Real Water had some sort of inspection of its facility done at some time?
It is my belief that Real Water would be in compliance with federal and state rules and regulations as required by the supplier agreement.
And if so, they would have had some sort of inspection, correct?
If they were inspected, yes.
Did UNFI ask Real Water for the results of any sanitation or food safety audits?
No, we did not.
And that would be true from the entire time period 2012 to the present. You didn't ask for any audits, correct?
Correct, because they were an ambient, low-risk product.
Right there, Your Honor. That's their excuse for not doing what everybody else in the industry we're doing. Ambient, low-risk product. They made a judgment that they could cut corners, put people's health and safety at risk, because in their view, it was an ambient low-risk product. And that's why the 3 prior recalls, including the Whole Foods recall, are notice of a defective and dangerous condition of bottled water plant in general. That's why they should be admitted. Next one, please. I think it's Mr. Capadia. Excuse me, that was Mr. White's 62.2 through 63.3. This is Mrs. Capadia from 2074 to 2082.
Quick second.
So based off of the due diligence that we had done, it was okay. But now, again, now knowing the history of potential additives or issues that happen with bottled water, it does change our scope of what we would be focused on, and it does move water up, bottled water up in our assessment from a risk based off of the history. But prior to that, there were no instances that were brought to our attention that would cause us to bring that risk assessment up.
So UNFI has changed the general risk assessment for bottled water as a result of this case?
I would say not just UNFI, I think the industry in general around foods, around water and, infused waters, et cetera.
Including UNFI?
Including UNFI. Because there's more knowledge around what could happen if things were not done correctly.
Your Honor, we didn't have to have this incident. We had 3 prior incidents that they knew about. One, the Shaw's one was why one of the witnesses who testified, he was employed at Shaw's when they got that bottled water recall. The second one was a Whole Foods bottled water recall for arsenic. And the third one was widely known. So for them to say, oh, well, us not doing third-party audits is justifiable because no one knew about the problems, everyone knew about the problems, and that's why everybody else was doing the third-party audits. So for those reasons, the 3 prior recalls are admissible. And I think the next one we have is the FDA exhibit. This is a rather remarkable warning letter that the FDA wrote to Whole Foods. And I say it's remarkable because, as the court knows, I've done pharmaceutical litigation for almost my entire career, and I've never seen anything like this before. So they wrote a letter. Go up to the date so we can get the date, please. Right there, December 16th. So they wrote a letter to Whole Foods, they being the FDA, and go down.
And what's the date of that, Mr.?
December 16th, 2020. So they're talking about all the prior recalls. Now, the recalls Mr. Neale showed you are the 2021 recalls. Those are not the recalls that are subject to this letter, okay? So I assume he has those somewhere. I don't know why he didn't show them to you. But this letter talks about different recalls prior to this time. So what happened is the FDA went in and analyzed all the recalls that Whole Foods was doing. And they call it the pattern of recalls. And they find, quote, these recalls demonstrate that your corporation engaged in a pattern of receiving and offering for sale misbranded food products for the time period of October 19th to November 2020. That is squarely the time period of this case, Your Honor. The outbreak cases started emerging in November 2020. So at the exact same time that this case, a lot of people were getting injured, these people were engaging in a pattern of recalls that the FDA is criticizing here. They say they're all misbranded, you know, and Mr. Neale can go, oh, well, one of these is for peanuts and one's for this and one's for that. That's not the point. The point is we have an FDA letter that talks about the pattern of recalls of this corporation. Okay, and again, this letter was no, you know, I'm surprised Mrs. Capadia claims she never saw it before. This letter was big news, okay? When you get cited by the FDA like this, there's FDA publications that come out weekly, you know, and Ms. Capadia says, oh, we monitor all the recalls. Well, gee, you didn't know that your biggest supplier, I mean, your biggest customer, Whole Foods, got this kind of letter from the FDA? But this just goes, I think, further to prove why, if you're not auditing people, there's going to be problems. It proves that this entity did not engage in safety. And Your Honor, those are the reasons that the 3 prior recalls in this letter are admissible. You know, and Mr. Neale's going to stand up in front of the jury and say, oh, well, none of these bottled water things involve hydrazine. Well, you know, when you don't go in and put boots on the ground and look at the facility, it doesn't matter whether it was hydrazine or not. As you saw from Mr. Heidel and Mr. Pham and even their witnesses, if they had seen these things that are disclosed in this audit, they would have suspended this, and that's what they should have done. But in any event, that's why these are admissible, to attack, undercut, rebut, whatever you want to call it, this ambient, low-risk product defense that they're raising. Thank you, Your Honor.
Thank you.
All right, we got pretty far afield there from the subject of the motion to eliminate. We'll have plenty of time to talk about audits. I don't expect to ask the court to ever tell Mr. Kemp he can't talk to the jury about Whole Foods' decision to audit or not audit real water. But let me, in rebuttal, point out a few things. These are bottled water recalls, not involving UNFW at all. Not involving alkaline water at all. Not involving the presence of a toxin or an adulterant in the product at all. No E. coli, no arsenic above the 10 parts per billion limit, except for 2,000 cases that Whole Foods on its own recalled. Whole Foods, Your Honor, is not a party to this case. What a retailer does or doesn't do is not going to be the subject of anything in this case because there is no retailer here. For whatever reason, Mr. Kemp decided not to sue Whole Foods. He told the court a moment ago that Shaw's, Stop and Shop, Albertsons, Food Lion, Winn-Dixie, Publix, and Kroger all, as of 2004, audit all their suppliers. That's wrong. And I'm tired of having to correct the record as blatantly as this. Can you please, John, play the didn't audit all supplier clip from Mr. Brown's deposition? I believe it's...
And at that time, Shaw's had 6 employees doing annual inspections of the 320 suppliers. Is that correct?
Yes.
This is the portion he showed you.
I didn't show that portion.
And is that standard in the industry for a supermarket chain of that size to do annual inspections of its suppliers?
Objection of form. You can answer.
Yes, I believe that was probably standard.
Not to audit all suppliers.
Other people were doing it.
Yes, other retailers were doing it as well.
And you know what other retailers were doing annual inspections of their suppliers back in, where were we at, 2004?
At that point in time, Albertsons, Stop and Shop, Food Lion,
Anybody else you were familiar with?
Winn-Dixie, Publix, I think most of the major supermarket chains, Kroger's.
Okay, just help the court reporter out here a little bit. Winn-Dixie is W-Y-N-N, new word Dixie, D-I-X-I-E, correct?
Yeah, Win is W-I-N-N, and then Dixie, D-I-X-I-E.
And Publix is P-U-B-L-I-X,
Correct.
and Kroger is K-R-O-G-E-R, right?
Yes.
Okay, so those 6 chains and Shaw's were all doing, to your knowledge, annual inspections of their suppliers, right?
Yes.
This is the key.
Of their own label suppliers, not, it's a private brand, not a branded product.
We've completely misrepresented the record again.
You have. I agree.
It's not all suppliers. The witness never said that. The witness said the opposite. Private label only, not branded products. Real Water is a branded product. He named 6 supermarkets, retailers, not distributors. It's the exact opposite of what the witness says, but Mr. Kemp stands up here and tells the court that in 2004, everybody in the industry was doing this. That's flat wrong. And at some point, it's just gotta stop. We can't misrepresent the record like that. He said that Whole Foods, not UNFW's, but Whole Foods' excuse was, we didn't know there was a potential risk of bottled water. That is absolutely not true. Every product has risk. And when they say it's an ambient low-risk product, ambient is not a classification that they make, it's not an opinion. Ambient means it's not refrigerated or frozen. It refers to the temperature. I don't know whether Mr. Kemp doesn't know this, or whether he's deliberately misrepresenting it.
But didn't he testify in the prior testimony that the reason why they didn't inspect the property because it was ambient?
Because it was an ambient, low-risk product, right? And I'm gonna go through that if I can. But that has nothing to do with the motion to eliminate.
But I mean, but ambient, low risk, right?
Yes.
I'm looking at it from a low risk perspective, because at the end of the day, ultimately, why wouldn't that be a jury question as to whether or not it's a low risk product?
It absolutely is, Your Honor, but the recalls have no bearing on it whatsoever.
But shouldn't the recalls be potentially relevant as to whether or not it's a low risk product?
No, Your Honor, because the recalls are a preventive measure. That's like saying if there's a hazard control point, a hazard analysis and critical control point on a product, it must be a high-risk product. That's not the case. The recall mitigates the risk that's there.
But you're taking a position that there was no need for an audit because it was an ambient, low-risk product.
No, Your Honor, I'll get to the real.
That's the way I understand it right now.
Well, I'll get to that
That's what
correction.
he testified to. You know, let's not quibble with argument. And the reason why this is important, because if there's an appeal, I want the Supreme Court to understand the reason for any decision they make in this case. I mean, and that's what's critical, because I try to make a good record. I've been told I make the best record. I don't mind saying that of any trial judge. And to me, it appears to be a really important point. If your client's saying, look, we don't audit because we think it was low risk, we can take ambient out. Well, whether it's low risk or not, I mean, there have been prior recalls regarding water products, right? And here we have a scenario where there was no audit whatsoever. I understand you're making a distinction between a label versus a brand and so on and so on. But this plant had a lot of problems.
This plant had a lot of problems, Your Honor. There's no question about it.
They did.
And it's absolutely fair game to talk about whether a retailer should have audited. That's not what we're talking about here. In the recalls, there's not a category of food or beverage product, Your Honor, that hasn't been recalled. Not one. because the food and beverage industry does the right thing and tries to recall products before risks cause injury. If the measure of whether you should audit or not is determined by whether there was a recall of a different product for a different reason in that product category, then there'd be audits, there would be no such thing as a low-risk product. There'd be no such thing as an exemption under the federal regs, which I'll show the court in 1 minute.
But coming back to it, does it really matter whether it's arsenic, E. coli, any other adulterant? And my point is this, it seems to me from a food safety perspective that any product could be high risk if it's not audited, right? And that's kind of my question. And I know you're smiling, but understand this. I mean, this is products liability law, right? And I understand specifically why Mr. Kemp asked questions in such a form and fashion when he talked about red flags. That's coming straight out of Countrywide, right? I get it. I mean, I understand what's going on. But my point is this. If your client is taking a position, they're saying, look, we think it's low risk, right? That's the position they're saying, taking. We'll take Ambien out. It's a low risk product. And their position is, oh, it's not a low risk product. That this product should be audited by UNFI. I get it. Whether Mr. Kemp's right or whether he's wrong, whether it's a low risk product, why shouldn't that go to the jury?
That question should go to the jury, Your Honor. Okay. The existence of the prior recalls does not bear on that question.
Okay, well.
And if I may.
But how do you establish whether something's a low risk product or not?
Yeah, sure.
Could be prior incidents, potentially. And here's my point. We're talking about water. Shouldn't we be talking about any product that's potentially consumed by people, right?
No, Your Honor. There are different categories of food and beverages. And the FDA makes very clear what the risk assessment is supposed to be based on. And I'll walk the court through that in a moment. But there is not.
But the witnesses, did they make reference to the FDA? I mean, am I missing something?
Yes, Your Honor. The witnesses all make reference to the governing regulations, which Mr. Kemp is, in other motions, trying desperately to keep out. Because the government regulations don't require a distributor of packaged, unexposed, ambient, low-risk product to do any audit whatsoever. In fact, they specifically exempt distributors like UNFW from doing any supplier verification at all. On-site audits, hazard analysis, paper reviews, asking for audits, anything. And I'll walk the court through that. Mr. Heidel, Mr. Kemp's hero, that you just saw the video clip of, shows that very clearly. So let me make one more point. Real Water was audited annually. They were audited publicly by Southern Nevada Health. They were audited privately by NSF. Mr. Kemp is standing here and telling the court that Costco, which does audit all its suppliers, a retailer, and NSF did the right thing. Mr. Kemp is suing Costco and NSF. They never, ever, nobody, not Southern Nevada Health, not the FDA, not NSF, ever stopped buying Real Water after any of those audits. Mr. Kemp told this court that was because of the audit findings. That's absolutely not the case. Mr. Stevens, can you please pull up Castillo, page 98, lines 13 to 25? That's another just misrepresentation, Your Honor. And it's got to stop. Costco did not stop buying Real Water because of any audit finding. They stopped buying Real Water because they didn't have room for it, as Ms. Castillo says here. We were selling so much of our Kirkland Signature 40-pack that we needed space just for the sales for that item. I mean, we were having runs on water. It was the pandemic, so we had to make more floor space to sell the Kirkland. So we discontinued almost all waters, at least in San Diego and Harvard. Nobody cut Real Water off because of anything they found in the audit. And as Mr. White said, even if he'd seen that audit, he wouldn't have cut them off, he would have started an investigation. He would have gone there and did what Costco and NSF did. And they would have fixed it, just like they did, so that on the re-inspection, a couple months later, they passed and everybody continued purchasing water from Real Water. Your Honor, the issue in the motion to eliminate is the recalls, but we talked about the audits. John, can you go please to HUT exhibit, the HUT deposition at page 110. This is the plaintiff's food safety expert. And this is why, Your Honor, it's important to keep in mind the difference between a retailer like Costco and Stop and Shop and Shaw's and Kroger and Publix and Winn-Dixie, and UNFI, the distributor, the warehouse operator and truck driver. Page 110, line 8, please, John. And we're going to scroll through about a page here, if we can. If you can highlight line 8 from the bottom. Start with line 12, if you would, John. And I asked Ms. Hutt, this is a distribution case. You understand your opinion about UNFI's distribution specific. Ms. Hutt, the plaintiff's food safety expert, said, the scope of my opinion is to look at the standards applicable within the industry and to a food manufacturing facility. That's the scope of my opinion. Okay, not a distribution facility? That was not the scope of my engagement in this case. And not a distributor within, you've got no experience and did no research. Next page, please, John. That was not the scope of my engagement, for my opinion, in this case. Okay, and if the standard, the gold standard, as Ms. Hutt said, Dr. Hutt, excuse me, is to require distributors to do audits of suppliers, you would expect to see that in the SQF, the Safe Quality Foods Distribution Audit Form, correct? Dr. Hutt says, I don't know the content of the distribution standard and how they would address management of suppliers. So I would like to see the document and have an opportunity. Then we asked Dr. Hutt, the plaintiff's food safety expert, do you know what the warehouse exception is? In 21 CFR 117, she did not, Your Honor. This is the warehouse exception. Can you pull up 21 CFR 117, please, John? Your Honor, I'd ask the court to take special note of this federal regulation.
I was looking at it. Is that in appoints and authorities?
Yes, sir.
Okay, what page? I just wanted to...
It's certainly in the motion for punitives.
But is it in the motion in limine? Because I don't remember seeing it.
It's not, Your Honor.
Because I was just, I mean, I read it, I was wondering if I missed something. That's why I was going back through it. Okay, but we can move on.
Your Honor, and this is where the low-risk ambient role of the distributor is key. This is the FDA exempting UNFW in Part A. Subparts C and G of this part do not apply to a facility engaged solely in the storage of unexposed packaged food. John, could you click on G, please? G is supplier verification. Warehouses and distributors don't do supplier verification. That's why Dr. Hutt didn't know about it. That's why every example Mr. Kemp has given is a retailer, not a distributor. The entire regulatory scheme is based on the people who sell food to consumers doing supplier verification, not distributors. And if you could go down, John, please, to let's go down to 117.410, if you could just keep scrolling. This is what a supply chain program can include, or must include for the people who are subject to it. Using approved suppliers, determining appropriate supplier verification activities, and conducting those activities. Can you keep scrolling down, John?
What does that mean, determining?
It means section B.
Wait, go back.
Yes, sir.
explain it. It says determining appropriate supplier verification.
Yes, sir.
activities, including determining the frequency of conducting the activity as required by, what does that mean?
That means in subsection B, the following are appropriate supplier verification activities. Can you scroll down, John? One example is an on-site audit for entities that have to do supplier verification, which again, entities that hold packaged unexposed food like UNFW are specifically exempt from. What Mr. Kemp is trying to do, Your Honor, is to use state law to impose a requirement that federal law specifically exempts UNFW from. I think that is the definition of preemption. These are the other things that constitute supplier verification. An on-site audit is just one example. You could test the material. You could review their relevant records. You could look at the supplier performance. Your Honor, that says supplier performance, not the category of beverages, not the category of food to which the product belongs. Supplier performance, that means real water. No recalls, no warning letters, no failed inspections.
What about on-site audits?
On-site audit is one of the 4 options for entities that have to do supplier verification. Those are all disjunctive. And again, Your Honor, let me reiterate, this is all Part G of 117. John, if you could go back to 117.7 if the court's ready. This entire subpart is what distributors like Kihei and UNFW and McLean's and Cisco and US Foods and UNFW are exempt from. We don't ask warehouses to audit. We ask warehouses to take care of the product between the time they receive it and the time they deliver it. That's what UNFW does. That's their business. They don't decide what goes on Whole Foods shelves. They don't decide who Whole Foods does business with. Whole Foods decides that. And that's why federal law exempts UNFW from everything that Mr. Kemp is trying to tell you. But even if they were subject to it, an audit is only one way for them to satisfy their duty. And an audit is based on the risk profile of the supplier. Mr. Heidel's deposition, please, John, page 83. This is the really sharp, really impressive president of the International Bottled Water Association who Mr. Kemp just extolled the virtues of. Heidel, the deposition transcript. Let me go to it, Your Honor, forgive me.
I have it in the system. If you give me the pages, I can put it.
You do have it? Thank you.
He just needs the pages.
83, John. Lines 14 through page 84, line 3. This is the gentleman who's done thousands and thousands of inspections. This is him asking me, did UNFI repackage the product in any respect, or just store it and move it out to a retailer? Never repackaged, never relabeled, never reformulated, sealed containers the entire time. Then that's correct, your statement is correct. Question, no audit, no supplier verification requirement, warehouse, right. Warehouse exemption under FSMA, the Food Safety and Modernization Act. Answer, exactly. And Mr. Heidel, that's consistent with your decades of experience in bottled water? Yes, sir. The plaintiff's expert doesn't cite a single distributor who's ever audited anybody. Mr. Heidel doesn't cite a single distributor who's ever audited anybody. The federal regulations specifically exempt distributors from auditing anybody. Distributors don't audit. Retailers audit. And retailers audit based on the risk profile of the supplier, real water. Not of unrelated recalls in the category of product for dissimilar potential pathogens that never materialized and never harmed anybody. That's why the recalls are not admissible, Your Honor. And that's why when we get to punitive damages, the court should grant summary judgment, because you can't impose a requirement under state law that federal law specifically exempts somebody from it. That's conflict preemption. And so for those reasons, Your Honor, we request and
Does federal law as it pertains to suppliers exempt them from punitive damages?
yes, Your Honor. It exempts them from liability, Your Honor.
If it exempt them from liability, why are we here? And my point is that you're saying that a supplier under products liability law is exempt from liability?
No, sir. No, I'm sorry. I don't mean to say that. That would be absolutely wrong. We have joint and several liability in this case because we sold the product. There's no way around that. That's Shoshone versus Coca-Cola bottling company. That's torts 101. What we don't have, Your Honor, is liability for a failure to audit because federal law exempts us from that requirement. There's a huge difference between the two. And that liability exemption applies with equal force to compensatory and punitive damages. And we'll get to that. I understand the court's interest in it, and I'm happy to talk about it. But I want to remind the court that the issue before it now is a much simpler one, a much more discrete one. And that is the applicability of 3 bottled water recalls involving different products with no pathogens that hurt nobody. And a warning letter that doesn't even involve a pathogen, but instead involves mislabeling. So Whole Foods, not UNFI. That doesn't implicate the audit process at all. That all happened in the store. What Mr. Kemp is trying to do is prohibited by the hearsay rule. It's prohibited by the subsequent remedial measure prohibition. And it's prohibited by the warehouse exemption in federal law. The court should grant the motion in limine, and I'm pleased that it's as interested as it is in the punitive damages motion for summary judgment for when we get to that. I'm happy to answer other questions you may have, but I think you understand UNFW, the distributor's position.
I understand, sir.
Thank you.
Mr. Kemp?
I think he gets the last one.
Oh, okay, I'm sorry.
Thank you, Mr. Kemp.
Yeah, I understand. And we haven't got to the punitive damages claim yet, right?
We have not, Your Honor. That is UNFI's motion for summary judgment number 1, that if we take everything in order, will come up after our 20th motion in limine. We just argued our 7th.
So we have another 2 weeks to get to that?
I hope not, Your Honor. And here's one small step in the right direction. What we just argued is actually 7 and 8, and I believe 9 is agreed to. I don't know if the court has questions or intends to rule on 7 and 8 or take it under advisement.
And I want to make sure I'm clear on one point, as far as the CFRs those weren't raised in the moving papers, is that correct?
No, Your Honor, this entire.
That's kind of my
argument- And he didn't bring it up at the beginning, so I didn't have a chance to address it, which I can, if it will
Well-
say what punitive.
Your Honor, if I could have one moment to check. We wouldn't have brought it up in the moving papers because, of course, the moving papers would keep the recalls out. Mr. Kemp raised the issue of audits in response. So let me look at the reply, if the court will indulge me for one moment.
Yeah, you can. I mean, I looked. The reason why it's this is we were somewhat getting far afield of what my inquiry was. All right, this is what I'm going to do, because I'm looking at it through this, in this respect, and understand this motions of only interlocutory in nature. They are. I haven't heard the punitive damage issues yet, it has not been developed yet, and so potentially my ruling is subject to change based upon that. But what I'm going to do at this point, and I'm really focusing on the testimony as it related to ambient. That was the testimony that was elicited. Now it's argued that that deals with the storage, but I guess the real issue is whether it's low risk or not. As to the basis, there was no audit performed. As far as the prior events, I guess it really goes down to, and I brought this issue out during some of the discussion, as to whether or not the product is low risk. And it appears to me that that's really the issue as it currently sits, based upon the motions in front of me. And I'm going to deny the motion that it will be without prejudice, but that's based upon the current status of the law in motion, because the regulations weren't brought up during the motion. I will have to probably deal with that down the road as it pertains to the summary judgment issue. But I'm looking at it based upon the decision not to audit or not to perform any inspections or any of those types of issues. Whether or not that's required or not, we'll find out. I don't even know if there's been a development of federal preemption in the subsequent motions. I'll find out as far as that's concerned, but I don't know. Because we're probably, what, 15 motions down the road?
There's no summary judgment for preemption, Your Honor. I thought there would be one, but there wasn't.
Right, well, that's another issue we have to deal with, right? So it's, what time is it, 3?
That would be both 7 and 8 to 9.
Yes. So we're gonna, let's take a break and then we'll try to do one more.
The next one's not opposed.
Next one's not opposed, Your Honor. That deals with other countries' food safety standards, and I think that's agreed to.
Okay, and that'll be granted unopposed. And where do we go from there?
Back to Chris Rand, Your Honor.
Okay, take a break and then we'll do that one.
Thank you, Your Honor.
All right.